All right, well, welcome to ethics follow-up. Apparently there were a lot of questions that came in from various corners, and it was decided that it would be a good idea to do this follow-up in order to flesh out some of these issues and questions that continue to pester people with respect to their conduct of their cases and their dealings with their clients. So this is ethics follow-up, and we're going to go through these slides, but we also are very open to questions and may even ask questions, just to put this in a more on a more informal footing, and to make sure that we attempt at least to leave no stone unturned. So with that, Ms. Samons.
So the questions that are in this presentation were submitted by attorneys from Lytle. And I first just want to repeat that these are the sources for the ethical duties. We went over it in the last presentation, but this is a quick guide. And so if you have any more lingering questions, you can go directly to the source. And then first, I just want to briefly talk about ineffective assistance of counsel, since this was at the end of the presentation last time. But basically, in Re Kristen H is the case that specifically says that parents' independency proceedings have the right to competent counsel, and it's also in the WIC code. And so therefore, that means that the parents have a right to effective assistance of counsel. This is the source of that principle. And just to quickly go over IAC, it comes from a Supreme Court case, which is Strickland versus Washington, and there's two different factors that both have to be satisfied. And it's a very high bar. So honestly, most cases don't result in an attorney being found to have provided ineffective assistance, right? Because first, the plaintiff has to show that counsel's performance was objectively deficient. So that means that counsel made errors that no reasonable attorney would have made. And again, it's a reasonable attorney standard, not a reasonable person, so the bar is a little bit higher. So even if that's met, which usually is met in a lot of these IAC cases, then the second prong has to be proven, which is that there was some sort of prejudice to the defendant, or that the outcome would have been different had that attorney not made that mistake. So again, in our cases, even if you make a mistake and you realize it, don't freak out, just talk to your supervisor and try to rectify it, because it doesn't automatically mean that you're going to lose your bar card and that there's disastrous consequences, okay? Having said that, here are some basic questions and some answers that you can be your best ethical self independent support.
So, does anybody have any guesses as to the answer to this question? Who is in charge of case strategy, the client or the attorney?
I am.
Yeah, absolutely. Your client has a right to decide whether or not they want to plead no contest or not. They have the right to decide whether they want to testify or not. But pretty much, you got to drive the train. You're the lawyer. You're the one who got the training. You're the one who's been here. You have the experience. So we don't. That is the answer to this question. Is there any lack of clarity on the answer to that question? No. Okay. I think we can move on from that.
Okay, what, if anything, should be said in a Marsden hearing to defend against a claim of ineffective assistance of counsel? So, Business and Professions Code 6068 says that an attorney has the duty to maintain client confidences, quote, at every peril to themselves. I said that at the last hearing, but it's very serious. At every peril to yourself. So it's really important that you keep confidences. Also, the model rules say that an attorney is supposed to take any measure to vindicate a client's cause or endeavor. So again, very important that you're advocating for the client. That is your job. You represent the client only, even if you think that... Okay, so having that basis, I would say my recommendation is to honestly not say anything or say very minimal comments against your client, especially if you would be revealing some sort of confidential communication. So perhaps the client is complaining about something that's in the record. You could maybe respond to that from the record, since that is sort of public, quote unquote, public information within your court. But for example, the attorney saying like, if the client saying, my attorney told me like, I don't have a chance to get my kid back and I should just give up, and you know that's a complete flagrant lie, I would not recommend that you say, no, that's a lie. I told my client XYZ, I told my client that they should like stop complaining because it's hurting their case and that they need to be nice to the social worker. I don't know. You get where I'm going with this. Don't reveal your client's confidences. Honestly, you are weighing the professional damage to yourself, which is honestly minimal in these Marsden hearings. These bench officers see this all the time. There's a lot of heated clients in our court, and just because a client is saying that you did something wrong, the bench officer is not necessarily going to believe them. And so you're weighing the professional damage to yourself against the damage to your client's reputation, which could be very huge. If you reveal something that could make the judge think that your client is crazy or that they are inappropriate, it's going to impact their ability to get their child back, and we don't want that. So my recommendation is to not say anything.
Christina,
Yes?
what do you do when there's a Marsden and the court officers don't leave?
So there is no actual requirement that the courtroom be cleared for a Marsden hearing. It's general practice because it maintains client confidences, so I would say that and ask the court to ask the bench officers to leave, because again, it could be prejudicial to your client, and there's not really a need for the bench officers to be there. But having said that, there's no actual rule, there's no authority that you could cite to say that they have to leave the courtroom.
Are there any other questions about Marsden hearings?
I have another one. Are there any circumstances in which, if your client says something you think is prejudicial, you can then file like a 170.1 to have it transferred to another bench?
I don't see why not, but I would talk to your supervisor. I mean, you have to, 170.1s are a tricky issue that's sort of outside the scope of this presentation, but if you think that that would benefit your client to file that, and you think that there is actual prejudicial issue that the bench officer would have against your client for what they said, it's worth considering. So what do you do when you ask to talk to your client and they bring another person or friend or rando with them? Again, confidentiality will be waived if there's a third party. So again, the client can waive the attorney-client privilege by having that person there, but I strongly recommend that you advise them to talk to you alone and say that if you are going to persist in having this third person there, that person could be called to testify against you. You don't know. There's no, basically all bets are off, and that information that you are telling your client is no longer confidential and no longer falls within the privilege. Usually when you say that, most clients are like, oh, okay, and they like tell their friend to go sit down or whatever. So that's what I recommend.
But I mean, there are cases where, situations where the person is just like, no, they have to be here, you know, blah blah blah. Your only recourse in a situation like that is to repeat yourself and try to be very clear with your client and make them say to you, I understand what you're saying. I understand that I am waiving the confidentiality between us, the privilege between us, and best practice would be to handwrite something out on your activity sheet that is in their words, or you know, that they're going to sign, and make them sign it. Because like as not, at some point in the future, maybe this comes to haunt you, and the person's like, well, I never said that. And then you can go to your little activity sheet and say, here, see, like I wrote this out, and you signed it. So you did, and it's here. Because it's so crucial. It's such a critical relationship with the attorney-client relationship and the privilege that you have there. You want to do everything you can to avoid them waiving it, or at least avoid them coming back to bite you and say, oh, you never told them, you didn't explain it to them. You know what I mean? Does that make sense to everybody? To use your activity sheet to write this out and have them sign it. If you really are concerned that they're going to come and get you, and even if you're not that concerned, if you have the time to do it, why not just do it and protect yourself? Make sense?
It also might help to just tell them it's nothing personal, it's nothing against you. I say this to all my clients. It's about protecting you and protecting your interests. Maybe that will help. I don't know.
How much client communication is enough to satisfy your duty of communication? Are you required to provide periodic reports in writing, PowerPoints to your clients when there are no substantive updates in their case? So with us, we're swimming in a different sea than everybody else pretty much. We have too many dang clients, we have too much dang work to do, and it's really, really difficult. And a lot of times what ends up happening is the squeaky wheel gets the grease. And in a way, there's something good about that. I mean, there is a requirement that you maintain a reasonable amount of communication with your client in between hearings. And obviously, once you're past disposition, there could be 6 months there. And, you know, there's various ways for you to remind yourself to try to stay in touch with them. I mean, but obviously, there are many situations where the whole 6 months goes by and you've had no contact with them except for the letter. You should definitely use your little number to send them this number 6 letter or the 5 letter. If you want them to call you and you don't have the time to reach out to them, send them the letter that says, please call me. That way, when they don't call you, there's the letter, and then the letter gets returned, and they're like, well, you didn't ever send me that letter. Well, this is the address you gave me, this is where I sent the letter, and look, it came back to me. So this is all covering your bases, but you are required, you know, under the rules to maintain regular communication. But if there's nothing really to say, then, and your independency, then, you know, you have to weigh those competing interests. And most of the time for all of us, the interest, it's not even a question that you ask yourself. You're just running, you're treading water, trying to keep your head above, and you don't do that. But if somebody calls and they're like, hey, they're coming to take my kids and blah, 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 you're gonna call them back. So, you know, I open this to the floor, to other people, what techniques they use. I mean, I know there's some people who, you know, are pretty good about putting ticklers in their Outlook to remind them to give certain people a call because they know that it's going to be a problem. Other people don't, you know, you don't worry about them because they're leaving you friggin' messages every single day, or 10 or 15 times a day. So those people, it's a different story. But does anybody have any suggestions, or would they like to share how it is that they manage their kind of duty to stay in touch with their clients? Takers? Did I cover all the bases pretty much? So there it is. You know, I mean, I'm not sure who asked this question. I'm sure it's somebody who is, you know, less experienced in this racket. But you're just, this is just one of those irreconcilable problems. It's always going to be an issue. And what you need to do is be calm. And when you have a client who's just demanding, you need to learn how to say, to stop them. And to say, I'm going to hang up now, I've told you what you need to know, please just do it, and you know, you can call me back, leave me a message, you know, we can talk whenever. But, you know, I had an attorney today on the floor, on the phone with a client, and you know, he was doing a beautiful job of communicating to this person, but fundamentally he was robbing himself. He was robbing Peter to pay Paul. He's robbing himself of time because there's nothing he can really do for this person once he answers their basic questions and once he gets the information that he needs from them. The reason he called them was to get 2 bits of data. And once he got those, he needed to get off that phone. And it was difficult, and he's working it out, but we all have to come to a place where we understand what our priorities are when we get on the phone with a client. And the priority is not to listen to them tell you every single friggin' thing that the CSW has done. Does that make sense? Okay, are you required to respond to a client's repeated and or redundant requests for case information? What is adequate file documentation? So here, you have a duty to give them the report at attention, right? The department rarely is satisfying their duty to, or their, I don't know if it's their duty, but they're supposed to send the reports, but frequently you look at your little notice and, oh, they didn't send the report with the notice. So, you know, your client wants a copy of the reports. They have a right to have those reports. They're gonna, if they want the file when the case closes, they're gonna get the file so they can get it then. But, you know, you're not, these redundant requests, it falls under the same thing we were just talking about, or I was just talking about, which is like, yeah, within reason, you know, but you're not, this is not something that you're gonna put like at the top of your list. Oh, I have to make sure all my clients have, you know, their interim review reports. No. No. You know, and rarely do they, if they ask for it at the court, well, you know, if you have a moment, you got a copier machine in your courtroom, so now you could give it to them. So what is adequate file documentation? We talked about this before. This is super critical to all of us, because when you're documenting your file, number one, you're leaving notes to your future self. Like, you're not going to remember this case. I mean, some of them you do, but most of them you don't. You maybe remember the name and a few characteristics of it, but like, what was actually going on, and was there something significant that happened? Where is this case, right? So, and they shouldn't be. Your documentation, the notes to yourself and the notes to coverage attorneys shouldn't be haiku, but you know, in the spirit of haiku, they should be simple, direct, to the point. Substantive.
I support a haiku approach.
Dennis supports a haiku approach. I support a approaching haiku approach. So adequate file documentation is just the basics of what happened at the hearing, and if something happened where if you get a like, oh, this is one of these people who's going to come back and they're going to say, blah, 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 blah. Write that in there and write down the substance of what it might be that you think they might come back at you on, and what you did about it. You know, did you make that? Did you follow up? You know, you said, when you said to the client when they were leaving, I'm going to talk to county counsel about your visitation. Did you actually do that? Do it. Don't make promises and don't keep them, right? So, again, adequate file documentation is. It's a loose, or it's not loose, but it's definitely not the same for each file. Question?
Well, comment. I was just going to say adequate file documentation is when your client calls and complains to your firm director, what is going to make your firm director happy when they look at your activity sheet? Yeah, always. Whatever phone messages needed to be documented there. Because that's when it's really going to matter, is when your firm director either found everything they needed to take care of the call in the file, or they come and see you. They're constantly checking to see when you're coming back from court so that they can grill you on it, and the answer is, yeah, why wasn't that in your activity sheet? So write these notes for your firm director.
And there's no specific ethics rule that's going to... There's no specific ethics rule that tells you what you're going to have to write to avoid like state bar misconduct, right? They're not going to spell it out. So really, it's just about making sure that you are writing everything down in your notes that can make you be an effective, competent lawyer and to communicate well with your client and to the other counsel on the case. So I recommend putting all consents of your client. Anytime your client consents to something, write it down. Any contacts you have, even if they didn't pick up, write it down so you have that proof of that record. Any investigation into the allegations that you do, that's pretty important. And any goals of the client. So this is a rule that I learned from Dennis, which is basically to know what the outcome of the case is when you first get a case, right? A parent is going to be able to tell you, like, I want to get my kid back. Okay, then that's the goal, and you best be writing all your stuff in your file about what you did to get that goal, what stuff they said that they did in furtherance of that goal. And also, in addition to writing notes for your supervisor or law firm director, write it for your fellow attorneys, because I didn't put this in here, but we got a question about, what do you do if you get a file and it's basically a mess and you don't feel like you could ethically represent this person based on the file? Yeah, that happens, I'm going to be honest. And so don't be that person in your firm. Don't be the one with the reputation of not putting enough information that when another person covers your file, as they inevitably will, they have no idea what to do.
Can we also talk about legibility?
Sure.
I don't want to talk about that.
The question was, can we talk about legibility? But I think just the question.
I think we just have. Yeah, we just did.
And then also from the writ department is, on your activity sheet, not on your court appearance sheet, excuse me, not on your activity sheet, on your court appearance sheet for that hearing, if there are exhibits admitted into evidence, please record those on your court appearance sheet. There may be, sometimes people have their exhibit list, but those go on the left side. But the things what we always do is look at the last court appearance sheet. And it's crucial. That's evidence. We need to know. So it's a very good point from our writ department. please, if there's evidence admitted, just notate it there, that it was admitted. And remember that there's a difference between the court appearance sheet and the activity sheet. So the court appearance sheet is definitely haiku, and it's definitely the facts, the basics, everything that happened in as clear and concise a manner as possible, and organized. I mean, some people have little boxes on their things, they put them in themselves, that's nice. You know, whatever it is you do, just remember, you're writing this to yourself, you're writing it to the coverage attorneys, and you're writing it for your supervisor and firm director when they do your evaluations. And that's important for you, because evaluations, you want them to be good, not bad. Anyway.
Okay, we got a lot of questions about conflict, so this is kind of general, but I'm just going to flesh it out more than the last training. What constitutes a conflict? So I broke it down in basically 3, and imputed conflict should be under former clients, so just keep that in mind, my mistake. So personal conflicts of the attorney. Now, I'm breaking this into 2 categories. One is attorney relationship with other attorneys. Okay, so it could be a conflict if you are married to the attorney who's representing another party. We see this in the courthouse all the time, and then there's procedures to take care of that where they're not put in the same courtroom, et cetera, but just be on the lookout. Also, that could come up if you're living with someone and they are representing an opposing party. So that's one example. Second group is business, financial, personal relationships with a party or witness in the case, or anyone that would be substantially affected by resolution of the matter. So if you, you invest in a business and then you see where this is going. I don't know, I can't really come up with a good example, but basically it's like, if you're a shareholder in some business and then you're like representing them, that could be a conflict. Or if you're opposing them, that's definitely probably a conflict. Again, that doesn't really come up in our courthouse, but just something to be aware of in general. So now, current clients. You cannot represent someone without informed written consent if there's a potential conflict in their interest, if there's an actual conflict. And that's pretty self-explanatory, so I'll just leave it at that. So former clients. You cannot represent a client who's opposed to your former client who has adverse interests. When I say opposed, then they have adverse interests. You cannot represent a current client who has adverse interests to your former client if you obtained confidential information during your representation of that former client. Okay, so
what if you suddenly find yourself in that position, though, where you end up representing, say, 2 fathers who have adverse interests?
Then you should talk to your supervisor and discuss with your supervisor and law firm director about possibly conflicting off the case.
Off of both of you?
Yes. Yes.
Yes. If you're already in the process of representing that second client. If you haven't even picked up that second client yet, then maybe you can still maintain the relationship with the former client and just not pick up the second. But in your example, you've gotten confidential information from both.
Yeah.
So you need a conflict on both cases. All right. So it does get very complicated, but again, I just refer you back to the original rule, which I put on the first slide. You can read it. It's very detailed, but in general, that's the rule. And conflicts are imputed within a law firm. This is not actually in the California Rules of Professional Conduct, but there's numerous case law in California about it, and that's when it brings up ethical walls and all of that stuff. So I'm not going to go into that, but ethical walls are a way to prevent conflicts within a law firm when you are representing a new client against a former client. And that's why we have procedures at Ladle to do checks and all of that. So I won't go into that. Lastly, another last personal conflict is sexual relations. I didn't go over this at the last one, but this one I thought might be fun. So in California, this is California Rules of Professional Conduct 3-120. So it's not okay if there's coercion or any like weird pressuring. Okay, I think that's self-explanatory. And you cannot do it if it causes you to become incompetent in your representation of that person. Unless, all of this is okay if the relationship predates the attorney-client relationship. So if you're already with this person before you start representing them, it's pretty much all good. But otherwise, don't do it. And I just really strongly recommend you don't do it. Just don't. So when can you waive a conflict? Sorry, the first one was a mistake. Clients can waive most conflicts of interest. They must be in writing, and it must be informed consent. So that's self-explanatory again, and in Ladle we won't really do that because it gets complicated, but that is the rule, that you actually can represent two parties that have a conflict if there's informed consent in writing. And just a side note that when you disclose any conflict to a client, you have to disclose the relevant circumstances and the reasonably foreseeable adverse consequences to the client of that conflict. So it's not enough to really say, oh, I have this conflict, that's it, cool. You have to explain the potential consequences to them, saying, well, you know, if something comes up where that conflicts with my former client, I can't reveal that information and that might disadvantage you. So that's something to keep in mind in general for your future practice. Okay, when can...
What is the conflict that can't be waived? You said most can be, but what's the one that can't be?
Okay, so representing opposing parties in the same litigation.
Ah, got it.
Like, the only opposing parties in the same litigation.
Got it.
And there's a case, I won't really go into it, but there is a lot of case law in this area, not in dependency, but just a lot of complicated cases with divorces, actually, where there's a couple that they have a business or whatever, they have an attorney for that business, then they go into divorce proceedings, and then that attorney wants to represent one of the parties, but not the other, and that's not really okay because there's a conflict, inherent conflict. Oops, sorry. Okay, so when must an attorney reveal the confidences of a client? The rules don't have any provision for that. You never have to reveal confidences of a client. Never. You never have to. Okay? When can you? One, when the client consents. Again, write that down because it's probably important to keep a track of that if they're consenting to revealing a confidence. Two, this is a long rule, but it's the one about the death or serious bodily injury, right? So you can reveal confidences to the extent reasonably necessary to prevent a criminal act that you, as the attorney, reasonably believes is likely to cause death or serious bodily injury. That's very long. But again, it's in the rules, and there's a lot of caveats. So again, you only reveal to the extent reasonably necessary to prevent a criminal act, not just like some, I don't know what, some non-criminal act.
So let's say your client comes to you and says, you know what, lawyer lady, you know what I did yesterday? I bought a gun. You know what I'm going to do with that gun? I'm shooting that judge.
Okay, do you reasonably believe it's necessary to disclose that to prevent a criminal act? Do you? You know this client. Do you reasonably believe that this client is likely
I
to
am
cause
well
death?
known for having rose-colored glasses. I think the best of everybody, so I don't think you want to come to me for that.
Okay, then.
But you're the one who's
What do you think?
who it's coming to.
Then you do not disclose. Again,
What's the answer to the question? When must you disclose a client's confidence? Never. Never. Kill that judge.
It's just
Go for it. I don't
Yeah, it depends which judge it would be.
honestly,
They're joking.
honestly, I'm not gonna I won't belabor this slide too much, but it's about your reasonable belief as an attorney. And attorneys have a lot of discretion, I believe, in these types of cases. If this actually goes up to some sort of disciplinary action, and you disclosed or you didn't disclose, you better be able to explain your belief and the basis of your belief. Okay, so it's really up to you guys. You have professional judgment, and you guys need to use it. But having said that, people get heated in our courtroom, so they say a lot of things they don't mean. Okay, so I'll leave it at that.
What if they break a window?
Before you disclose, also 2 side notes, okay? If you decide to disclose, again, not mandatory, if you decide to disclose, you, 1, have to persuade your client or try to persuade your client to not take that action and to not do that criminal act. Then 2, you have to inform your client that you may disclose to the appropriate authorities what they're planning to do.
And they'll kill you too. Okay, so you're one bullet, I'm putting 2 bullets in the gun. So they'll give you more of a chance to try to.
I'm sure they'll have plenty of extra bullets, Donna.
You have to, because the California State Bar holds confidences, and the California Legislature holds confidences between an attorney and a client to a very high standard. And the purpose of it, which I'm sure you all learned in law school, is that we want to have clients be able to express everything to the attorney without fear of getting reprisal, because otherwise the attorney can't effectively help their client, right? So we need to protect that at all costs.
So
now, if someone's going to kill you and you reasonably think they are going to, you can disclose that. And if your client is like in that moment very crazy and about to kill you, you don't have time to say, wait, I'm going to tell you, I'm sorry, I'm speaking really fast, and you don't have time to say, wait, I first need to tell you all of these duties of mine where, you know, I can disclose this, yeah, and they're about to shoot you. Like, okay, I think that the State Bar will understand that in this circumstance you couldn't comply with that rule, but that is the rule.
So let's say you're being threatened, continually being threatened, when it's not really mean. So then you finally get the feeling, no, this man means that they're threatening you, not anybody else. Isn't it easier just to file a motion to try to get relieved irreconcilable differences? We have conflicts without saying my client is threatening to shoot me. So then he's not put it off. It's just that I can't feel, you know, there's just something between our relationship that you need to get off. Isn't that the safest way? Then I don't have to say anything to anybody. I'm not threatening him, that I'm revealing anything. Why couldn't I just
So the question is, essentially, I think, correct me if I misstate, but the question is, instead of disclosing the confidence of your client, to ask to be withdrawn. And my answer is that those are 2 separate issues in my mind. So terminating the relationship between the client and the attorney is a separate issue, and that doesn't absolve you of your duty in the first instance. If you reasonably think that the client is going to do something to cause bodily harm, that doesn't relieve you of your duties.
But it's not the way you said, it's not an absolute duty. The first
It's
duty
not,
is
it's not.
not to disclose. So if I can find a better way to protect myself, but without revealing what he said to me, which would sort of put everybody at ease unless they wanted me to be shot, then I would file something to get off the case without having to tell him, you know, you threaten me continually, and this is, I think, the best way. I mean, I would let him know I'm getting off, because I think it's better for you to get a new attorney. Obviously, there's a breakdown, tremendous breakdown. So I can do whatever my judgment, but you remember, never disclose anything. And if you do, there's a lot of things you have to do before you disclose. Thank you.
Yeah, so I think that it's well within your judgment as an attorney to request withdrawal from representation. But in ladle, that's a much more complicated procedure that is beyond the scope of this. It's about policy and ladle policy, so I would go to your supervisor.
So this case, Leverson, you guys all, I think it's one of the handouts. The essence of it, the call of the question was, you know, I'm just going to read this. The question presented is, what standards govern disposition of a motion made during a criminal trial by a defendant's attorney to be relieved as counsel because of a conflict of interest arising out of the attorney's representation of another client in a different proceeding when the nature of the conflict is unclear and, according to counsel, cannot be clarified without breaching the other client's confidences. So basically, this case stands for the proposition that the court, when you are declaring a conflict and you're telling the judge, there's a conflict, and the judge says, well, why? What is the conflict? And you cannot reveal that, the judge has to roll with what you're telling them. Basically, that's what this case stands for. So it's an important case to understand, because the court in this case said to the attorneys, and what happened was that they were representing one of the criminal defendants, and then another person was brought in as a witness, and it turned out that that person they represented as well on another similar matter. And that person, it turned out even further, was implicated in this case as an uncharged defendant. And all of these things were uncovered as they went. So there was a question earlier about, well, what if you don't know? Well, your duty to avoid conflicts of interest is ongoing. It doesn't ever end. So if material information becomes available to you at this moment in time, then that's the moment in time when your duty kicks in, and you have to take corrective action of whatever nature it is. So the court's basis for denying, because they asked the court to be relieved, and the court said first that it stated that there was no showing that counsel had confidential information that, one, would impeach any of the trial testimony, and that was true, and two, would be available to substitute counsel. But the lawyer's argument was, well, yeah, it's not available to substitute counsel now, but isn't it the case that the lawyer could ferret out the information from other sources? And the Supreme Court ended up agreeing that with the petitioner here. But in any case, the court also said to the counsel, there has to be some clue to the court. That was in quotes. And there's no basis for even a reasonable informed speculation that a disqualified conflict existed. So basically, if you're telling the court that there's a conflict, and you're telling the court, I cannot tell you why, the court's got to live with that. And that's pretty potent, because you would think, I mean, I know when I was reading this, I'm like, well, gosh, you gotta tell them something. And there's a case that they cite to, Holloway, and the citation is in this case, so I'm not gonna bother with it, but it says, in Holloway, as here, the prosecution argued that to credit counsel's representations to the trial court would be representations that there was a conflict, but they couldn't tell them why, would be tantamount to transferring to defense counsel the authority of the trial judge to rule on the existence or risk of a conflict and to appoint separate counsel. In Holloway, the Supreme Court said, no, that's not we don't agree with that argument. And here, they agreed again. All right, the representations concerning conflicts, the attorney's representations concerning conflicts, should be given the weight commensurate with the grave penalties risks for misrepresentation. So we all know what's going to happen if we lie to the court. Everything that we have worked for all of our lives to be lawyers is at risk. So the Supreme Court is saying, yeah, they're not going to do that, right? Unless you're an absolute idiot, you know, and then you're throwing yourself to the wolves into the future, right? But otherwise, they're believing that we as attorneys are weighing these consequences, and we understand the implications, and we're telling you, Your Honor, this conflict exists, and that's all I can tell you. And they have to live with that. So understand this case, take a gander at it, and know it, because there may be a situation that arises even in our court where the judge is going to be like, no, you need to tell me. And you say, Your Honor, I don't. And then throw the case out. Questions? Moving on.
What is the staff attorney's responsibility when a supervisor orders the staff attorney to possibly commit a violation of ethics rules? So in the model rules, there is a specific rule that says that a subordinate lawyer does not violate the rules of professional conduct if acting in accordance with a supervisor's reasonable resolution of an arguable question of ethics duties. There is no such rule in California. So the California rule just simply states, a member shall not knowingly assist in or induce any violation of ethics rules. That's it. So ultimately, it's your bar card on the line, and so if you think that if you know, again, the key word here is know. If you know that there is a violation of ethics rules going on, then you shall not do that. You shall not do that action. Okay? And honestly, that's it. There's no other rule in the California rules of professional conduct regarding supervisor relationships with subordinates. Just as a side note, though, the comments to the competency rule in California does say that supervisors have a duty to supervise the work of subordinate attorneys and non-attorney employees. So they do have an additional duty to supervise. And so, I mean, if you are a supervisor, just know that you do have that additional duty under the competency rule. Does anyone have questions about that?
So many questions. If you email the bench officer about a perceived violation of court orders by the county council, copying the county council, is that an ex parte communication? Yeah. Don't email the judge. I don't even know where that question came from. Was that really a question?
I'm not going to reveal. I'm not going to reveal any information.
I mean, the answer is yes, it's ex parte, and the answer to the question, should you do that, is obviously no. Is there any clarification needed on that one?
What if the judge emails all the attorneys on a case? Can you respond to it? Reply all?
They're all on it.
I would say try not to. That would be my instinctive reaction to that question. But if you did, then yeah, reply all. For sure, reply all.
And my reply would be, why don't we do the whole case by email?
Can we start doing that?
Work at home days.
Next.
When you know that another lawyer has committed an ethics violation that raises a question as to that lawyer's honesty, are you required to inform the state bar or the court? In California, there is no rule. Again, there's a distinction between California and the model rules. So the model rules have 8.3, which says that a lawyer who knows, again, operative word knows, that another lawyer has committed a violation shall inform the appropriate professional authority. There's also a follow-up rule, 8.3b, that says that if the lawyer knows that a judge violates the ethical rule, they also have to report that. So that's pretty funny, but not a rule in California. Any questions on that?
But you should still go to your supervisor and your firm director.
Sure.
Yeah,
Who hopefully won't commit ethical violations too.
right.
So these are the last two, and really, I think, to me, these are the biggest issues that we just face on the day-to-day in our court. So we'll both talk about it, but basically, how can you comply with your duty of compensate when you have too many clients? And how do you decide how to allocate your time amongst your numerous clients? I know Joe touched on this before, and it's difficult, but...
I mean, there are certain people who I've noticed, the people that I've noticed are pretty consistent about being able to manage their time and manage their clients, are people who come up with systems to help themselves. And they dedicate themselves first to figuring out a system that works for them. So for me, the first person who I noticed had a system that seemed bulletproof to me was Emily Berger. Like, I just saw her every day, she was just on it. And then when I would cover her courtroom, I'd be like, damn, there's a lot of shit going on in here. And how does she do that? And so then I started, when I would talk to newer attorneys, and they'd say, well, how do I do all of this? I don't understand. I said, well, the best thing to do is to be calm and know that the day will end. And, notice who around you is handling themselves and handling their business, and talk to them. Ask people, what systems do they use to keep things under control? Because not everything that works for one person is going to work for you. Only one little thing might work for you. But you got to come up out of your hole of like, oh, there's so much stuff, and look around and see the people who have a little light shining off of them, and they seem to be handling it, and go up to them and say, hey, so what do you do about, do you have, a lot of people keep a written calendar. Like, to me, that's a no-brainer. If you're a staff attorney in a courtroom, you must keep a written calendar. But some people don't. Fine. It doesn't make any sense to me, but to me that's the beginning of organizing your life as an attorney at Ladle, is you have your own record of things. Also, actually being very careful and judicious about your JCATs, making sure that everything goes into JCATs that you care about. Now, some people don't care about RORs. I do. I want to know everything that's on, and I hate surprises. So when I'm stationed in a courtroom, I'm putting everything in there. But sometimes I come back and the person's like, please don't do RORs. I can't stand having, okay. Whatever it is, these are the things that you have to have systems in place. If you don't even understand what that means to be systematic, then, well, I don't see how you get out of law school without being systematic, at least a little bit. But I would recommend, number one, is just talk to the attorneys around you who you see just that are more or less usually pretty calm. they must be doing something to keep track of things, and I think it's important to consult in that regard. Questions?
Miss Ahmed.
I was just gonna ask Ms. Berger to share like how she managed like the phone calls, numerous phone calls.
Well,
and
the
meeting with
first
clients.
thing I always tell people is I give my cell phone number to everyone who, unfortunately I only speak one language, but to all of my English speaking clients, I give them my cell phone, and that way most people's phone calls don't require a 20-minute conversation. Most people want to call, they want to know they can reach their attorney, and they have like 1 or 2 questions. And so if I'm listening to my voicemail during a break in my day, I wasn't one of those people who was constantly socializing in the attorney room. I'm returning phone calls as they're happening, so then I'm crossing it off my list. And if it's something that I need to document, I would write a note of it on the back of the calendar and put it in my bag, so then when I went back to my office, I would type up a memo to file in the file so that everything's being documented and I'm knocking stuff out as it's coming, because the thing that would make me stressed is when I would look at my phone and there would be like 10 voicemails, and I'd come back to the office and there'd be the red blinking light. So I'm a person who I just like to clear it out. Additionally, I would say on my voicemail, I will return your call within 24 to 48 hours, because that gives the client a little bit of just that breather to be like, okay, I have a lawyer who's going to get back to me. I don't necessarily, sometimes they still do, but I don't necessarily need to leave 5 voicemails, right? She's going to get back to me within 24 to 48 hours. So that's really quickly, that's kind of and also I text when possible, because you can do that really easily when you're in court. So as much as you can do while you're at court, because so many of us are stuck in court, that's going to lighten your load for when you get back to the office, for when you need to process and do other type of case management. I'm happy to talk to you about more stuff.
So how many people here worked in a restaurant in your younger days? All right, so me too. So I don't know if you got yelled at by either your manager or by the head cook or whatever about economy of motion, economy of motion. If you're going to take this over there, then grab a cup of coffee and bring it over there. And when you come off there and you walk by that table, grab something off of it and bring it there. So that principle of always doing something useful when you're at a restaurant, and if you worked in a high volume restaurant like I did, where you're doing hundreds of covers every day, like every single second counts, and everybody's watching, because everybody knows if you didn't pick that thing up and it was there and you walked by, fuck you, so think about that in terms of your practice. Economy of motion. What can you do to maximize your time? I mean, if you're in the attorney room, I mean, sometimes you just need to sit down and take a breath, and that's totally reasonable. There's nothing wrong with that. But if you stuck a few adjudications from a couple of days coming up in your bag or in your box or whatever, or the phone calls come in, if you can just aim your practice toward economy of motion, or what I mean, doing things as you go, that's going to help. That's going to help.
The rules don't say kill yourself for the sake of your client, right? Like, you still need to sleep, you still have families, and we're not requiring you to work 24 hours a day, 7 days a week, although I know it feels like that sometimes. But just find what works for you and talk to supervisors, other attorneys for strategies. And if you have specifically like an E case, just know that you will have to put in more work for those. You will have to put in more time on an E, an F, maybe a D than perhaps just a drug case, and so keep that in mind.
And there's also one of the lessons of the great Dennis Smeal is don't work harder than your clients. Don't work harder than your clients. I mean, it's fairly regular that I come across somebody and they're they got this and they want to do this and about this file and this person, and the question is, well, what has the client done? Nothing. All right, well, that person doesn't appear to really care, and they're not really, they're not doing anything. So when you get to the 21E or when you get to the 364 and your client's got enhancement services and the report says they haven't done anything, and they haven't done anything because they haven't done anything, but meanwhile you prepared arguments, or you made all these phone calls you can't get them to do stuff if they're not going to do it. You can't, you know, it's a cliche, but you can lead the horse to water, you can't make that horse drink. And it's true of our clients, it's true of teenagers, it's just true. You know, so remember that too. Don't forget these basic things. Do not work harder than your client. Or know the, as she was saying earlier, another Smealism of know the end in the beginning. You know where this is going. That will, if you really take a moment to figure out, well, where is this going, that's also going to save you time, because you're going to know what you need to do to get it to where it's going to go. Does that make sense? Anyhow.
Any questions about anything?
It's a wrap.
Thank you guys.
Thank you, Joe. So complimentary.
Just on the table. Right here. Here. I'll take it. Yeah, I'll take it. Yeah, I don't know. Okay,
Do you remember that was one of my questions I asked in the interview? The supervisor told you to do something that you didn't think was appropriate?
And I was like, tell them to go F them.
Do it your damn self!
I'll take the white sheet. I mean,
Like 2 nights after I got